knife was in it. And he says, okay, well, we want to expel him. So let me get this right. You want to expel him because he didn't realize he had a Swiss Army knife in his pocket. He went and then told his teacher, did the right thing, and now because he did the right thing, you want to expel him, whereas if he had never told his teacher, he probably never would have been, no one would have been aware of the fact that he had this knife and violated school policy. Yeah, that's right. So the father is at this meeting. He says, well, hold on, are you telling me that my pocket knife is in violation of the school policy? Well, there was the principal and there was the superintendent at this hearing. The principal was a little snowflake. She had intentional infliction of emotional distress. She's apparently going to need to see a psychiatrist for the rest of her life. All because, and she doesn't dispute, he never opened the blade, he didn't point it at her, he merely took it out and placed it on the table. She says he slammed it on the table. The superintendent, who is not a snowflake, most likely a conservative, said, well, yeah, he pulled out his knife, set it on the table, and said, are you saying I'm in violation of the law? So what happens, to this young gentleman's surprise, is the Pennsylvania State Police show up. You're being charged criminally. Criminally? We're talking about a school policy here. What are you talking? Oh no, you had a weapon on school grounds, and that's illegal. So unfortunately, he gets an attorney who doesn't really know what he's doing that much. They go to trial, they go to a bench trial on the matter, and the judge says, well, you know, it looks like he violated the law. And the attorney says, well, look, Judge, there's this defense here. It says that it shall be a defense that the weapon is used and possessed in relation to a school activity or course, or possessed for other lawful purpose. He's a carpenter, he, you know, had it for this, so it's a lawful purpose. Judge looks at the statute and says, I'm sorry, counsel, it's not relative to the school activity, so he's guilty of it. And so this young man, he doesn't have a lot of money, or that says, you know, I'd like to appeal. His attorney doesn't comply with his ethical obligations, doesn't file the appeal. He does his own appeal, the client pro se, even though the attorney still had an obligation to be representing him. And what ends up happening is during the appeal, the court grants the attorney withdrawal, even though the attorney's not doing anything. And this young man has to litigate the case all himself. And the Superior Court comes down with what I would call an abhorrent decision, saying, yes, they affirm what the trial court did. And I saw this decision come down and I said, oh my God, this is horrific. This was an issue that whenever I did firearms law seminars, I always said it was a gray area. I always said it's one of those issues that really we should get a determination on, seek declaratory relief, because I know there's a lot of parents that drop their kids off at school and have their firearm in their car when they're doing it. And although my opinion was it was completely lawful, I couldn't say. Well, this decision said that unless the reason why you were on school grounds necessitated the possession of that weapon, it was unlawful. Now, think about that. Unless the reason why you're on the school grounds necessitated this weapon, and by weapon, it's anything capable of inflicting serious bodily injury or harm. That's pretty much everything. So, I see the case come down. Firearm Owners Against Crime sends one of their people out to find him. And we made contact with Mr. Gosselin, and I said, look, I know you have limited resources, you can't afford an attorney. Are you interested in us filing for reconsideration of the court decision? He was ecstatic. Because, oh yeah, by the way, I forgot to tell you this part. It's a misdemeanor of the first degree, so his conviction would preclude him from ever being able to own a firearm or ammunition forever in his life. So he says, yeah, absolutely. So I file a motion for reconsideration, making a number of arguments, and asking the court to vacate its prior decision, to permit me to submit new briefs because he had filed his own, and to provide us with oral argument. And to my surprise, the Superior Court gave us everything. I've never seen the court previously vacate a decision prior to an en banc full court determination. So we went in front of the entire court to argue his case. And I explained that there were a lot of reasons for which he was in the right. In fact, when you look at the statute, and I don't know if any of you caught it when I said it earlier, the statute says that you may use and possess a firearm relative to a school course or activity. The reason for that? Use and possession? Because a lot of schools, when they wrote this, had shooting teams. You needed to be able to use the weapon on school grounds, not just merely possess it. Also, a lot of schools had Boy Scouts and other organizations that would come and have items that were capable of inflicting serious bodily injury or harm, and they needed to be able to use those because it was part of the curriculum. The second part, the part that we relied on, says, or possessed for other lawful purpose. Notice, use is left out of that section. And so one of my main arguments, because what the trial court did and what the prior Superior Court decision did, is it conflated those two separate provisions into one. In order to have that firearm or other weapon on school, it needed to be relative to a school course or activity. I said no, because here the General Assembly said just possession, whereas in the first clause it said both use and possession. And then we went into other arguments, such as the single mother who has to drop her child off on the way to work, who would be denied her inalienable right to keep and bear arms and defend her life for the remainder of the day because she couldn't go back home after dropping her child off to get her weapon to go to work. Also, remember I said, think about that the reason that you're on school grounds needed to necessitate you having that weapon? Police officer is on school grounds for a DARE program. Guess what? Couldn't have a firearm on school grounds. The drug program doesn't necessitate having a firearm on school grounds. We came up with a whole host of arguments, including arguments relative to the fact that, guess what? All vehicles are capable of inflicting serious bodily injury or harm. Yeah? That tire iron to replace your tire, capable of inflicting serious bodily harm. So, thankfully, we got back a decision from the Superior Court, en banc, meaning entire court, that overturned that decision and basically said, as long as you lawfully possess that weapon on school grounds for a lawful purpose, you're entitled to the defense. Now, just be aware, it is a defense, so technically the Commonwealth could try to prosecute you, and you have to prove the defense, or at least assert the defense. Then they have to prove beyond a reasonable doubt that the defense doesn't apply to you. But that was a great case, because before that, my firm was very successful. In probably the 2 years leading up to it, we had 3 different occasions where individuals were found on school grounds with firearms, and we were able to dissuade the district attorney from bringing charges against our client based on those arguments. Now, we have black letter law from the Superior Court that supports those arguments, so we're in a lot better of a position. Then I wanted to talk to you, I kind of mentioned it earlier, John Doe et al. Versus Franklin County et al. This is the case where the sheriff is claiming high public official immunity. So what basically happens is, and some of you may not be aware of this, but your license to carry firearms applicant information is confidential, not subject to disclosure. It is a felony of the 3rd degree for anyone to disclose your license to carry information. And there are civil penalties for disclosing it, which also provides for attorney's fees and costs. Well, the sheriff in Franklin County, the prior sheriff, not the current one, was sending out unenveloped postcards that had all the applicant's information on it and saying, oh yeah, you can come pick up your license is revoked, whatever. So we filed a class action lawsuit against the sheriff because, well, let me take a step back. We didn't just go out and file a class action lawsuit. We asked the sheriff, we said, stop. We said, you're violating the law. You know what the sheriff said? Okay, I gave you a fair warning. So then we filed a class action lawsuit against him. And the Commonwealth Court held that, yeah, he violated the law, basically. They said, yes, this is all confidential, unenveloped postcard, can't do it because that discloses the information. So he appeals up to the PA Supreme Court, who's hearing the case right now. We're waiting for a decision from the PA Supreme Court saying, well, you know, I should be entitled to immunity. Nothing I should do should be subject to judicial review. Now that's scary to me. I mean, just think about that for a minute. So, oral argument before the PA Supreme Court went really well. Well, not so well for them. They were getting skewered. But it looks like the PA Supreme Court's going to come down, at least in relation to this issue, and say that high public official immunity doesn't apply. I did argue that high public official immunity is actually unconstitutional, that it violates, obviously, the Pennsylvania Constitution, and the justices seemed intrigued by it. There is generally a theory in the law called constitutional avoidance doctrine, where courts are not supposed to consider constitutional issues to the extent they can decide it in the favor of the person claiming the constitutional issue on a different ground, a statutory ground. My argument here, though, was that here, high public official immunity isn't in a statute. It wasn't enacted by the General Assembly, ever. It's a common law doctrine. And since it wasn't enacted by the General Assembly, the constitutional avoidance doctrine doesn't apply. And several of the justices seemed very intrigued by that, especially when they went up and said, well, Judge, we need this high public official immunity because we're arguing it in a whole bunch of cases. Which gave me the opportunity to say, Justices, this is the exact reason why you need to address the constitutionality of it and find that high public official immunity is unconstitutional. So now we wait with PA Supreme Court. We could see a decision as early as 8 months, or it could be 5 years. Hopefully, because this isn't that big of an issue, hopefully we'll see it sooner rather than later, but I don't know at this point. Another case to let you guys know about is the Keys and Yox versus Lynch case. Basically what that was a federal case where we challenged the constitutionality of denying someone in perpetuity their Second Amendment rights as a result of a mental health commitment. So in relation to Yox, as a juvenile, he gets committed. After being committed, he gets out, he's still in high school, he gets straight A's, he joins the 101st Airborne, he has incendiary devices, machine guns, everything you can think of at his disposal, comes back stateside with an honorable discharge, starts working as a state correctional officer where he has a firearm, but in his private life, he can't have a firearm. Now some of you may be saying, well, hold on, Josh, you just said he has a firearm as a probation officer, and that's right, or a correctional officer, excuse me. And that's right, federal law gives an exception. If you're serving the U.S. government or any state government in some form of law enforcement capacity, while you're in the scope of that capacity, you're exempt. But as soon as you clock out for the day, you're Dr. Jekyll and Mr. Hyde. You can't possess a single firearm or a single round of ammunition. So this was a great test case, in my opinion, because look, we could show that this individual was actively possessing firearms safely, but being denied as soon as he clocked out for the day. The second individual, Keys, it was in a similar situation. He was a Pennsylvania state trooper. He was older, though, at the time of his commitment, where he's going through a bad divorce, and he makes some suicidal statements in that, and imbibes in a bunch of libations, as I would say, for those of you not knowing what that means. He drank a lot of alcohol, and so he gets committed. He gets released. The Pennsylvania State Police originally placed him on desk duty. Their psychologists and psychiatrists clear him. He goes back to active full duty with the Pennsylvania State Police. He actually qualifies in the top 10th of a percentile within all of the PSP with his handgun, shotgun, and rifle. He's phenomenal shot. Everyone loves him. This guy's down to earth. He's not one of these who gets a badge and thinks he's above the law. And so he, too, can possess all these firearms, including select fire AR-15 while he's in his patrol car and that. But as soon as he clocks out for the day, nope, no firearms. So this Second Amendment as applied case went up. The federal district court in relation to Yachts found in his favor. It's too much to explain why. We're still waiting on the decision for Keys right now, but we think that that will likely be in his favor. But in relation to Yachts, it actually came out, I believe it was in October, and what happened was the government originally appealed the Yachts decision to the Third Circuit Court of Appeals, which is the federal appellate court here in Pennsylvania, and the new administration came in. And the new administration said, yeah, no, withdraw the appeal. And they actually withdrew the appeal. So he now has relief and is very thankful for it. Other case that I want to discuss with you is another mental health case that I'm litigating out in the Western District of Pennsylvania. This is Franklin versus Sessions. And this case involves an individual who was only 302, which is the first level of involuntary commitment. And you get no due process with the 302. One thing I left out is both Keys and Yachts, in addition to being 302, they were also 303, which is the second level of involuntary commitment. And there you do get a hearing. A 302 is only good for 120 hours or 5 days. If you want to keep the person longer, they must be 303. So getting back to the Franklin case, here, he's only 302. You don't get an attorney, you don't get to cross-examine any witnesses, you don't get to supply any witnesses, you don't get to submit your own evidence. In my opinion, you don't get a neutral arbiter, because guess who is signing that form to involuntarily commit you? The physician that's employed by the hospital. And unfortunately, there are certain hospitals, even in Berks County, that have not met someone that did not need to be involuntarily committed, merely because of the annual revenue that is generated from involuntary commitments. So we have a challenge taking place out in the Western District saying that if someone's 302, it's not constitutionally sufficient to strip them of a right. And again, now this individual, Franklin, he's another correctional officer. We can show he's possessed a firearm without difficulty for the past 10 years, yet the government wants to prevent him in his private life from being able to have a firearm or a single round of ammunition. I mean, how does that make sense? You can say, oh, well, when he's benefiting us, Judge, it's good to go. But as soon as he goes home, you know, all bets are off. We don't know what his mentality is. So those are a couple of the current cases. Do we have a question? This counties quasi-do, the county mental health departments do get some revenue back, but beyond that, the state itself doesn't generally, except through taxpayers to fund the county organizations on that. That's a little bit of a case law update. Obviously, there's been far more cases than that, but those are some of the more monumental cases from this past year that are pending or have been decided. So let's talk a little bit about open and concealed carry. I don't know, how much more time do I have? So I don't want to... Okay. So let's talk about open and concealed carry. A lot of people are surprised to learn that open carry is lawful in Pennsylvania. And it is. There are some questions about it, I will admit, and that's something I want to talk with you about, and why I tell everyone, even if you want to open carry, you absolutely should go out and get your license to carry firearms. And so one of the issues is that we have a Pennsylvania Supreme Court decision from '95, I believe it was, where the Pennsylvania Supreme Court acknowledged that open carry is completely lawful in the Commonwealth, with one exception. In the city of Philadelphia, in order to open carry, the General Assembly enacted a statute saying you must have a license to carry firearms. Everywhere else, the Supreme Court said it's completely lawful to open carry. So, why am I concerned? Well, the one issue is we have some absolutely draconian transportation laws. and firearms. You must go to and from certain locations with the firearm unloaded, and if you don't, if you make a side trip, you violated the law. And oh yeah, that's a misdemeanor of the first degree, so you'll never own firearms again in your life. So some of you may say, yeah, come on, Josh, how is this likely going to play out that, anyone's going to figure this out? I get a call from my buddy, I throw the firearms in the car, I go out to the range, we put some lead down range, build up an appetite, I don't have my license to carry. My buddy asks me, well, how about we stop for a bite to eat on our way home? And I say, sure, and we do that. Well, you just violated the law because he didn't have a license to carry firearms. And they say, well, come on, how's that going to ever be known? Well, let me give you two examples with completely different outcomes, and one of which happened in Philadelphia, so you already know the outcome there. So this individual goes to the shooting range. He's practicing his draw. He has his holster on his hip. He's practicing his draw at the indoor range. On his way home, he had called in a script for CVS. Now, CVS is literally on the road that his house is on. It's virtually just turning into a parking lot to get into CVS on his way home. So he turns into the CVS to pick up his prescription, not thinking anything's wrong. His firearm and ammunition are in separate compartments in his trunk. Walks in the back, asks the technician for his medications. They give it to him. By the time he hits the front door, it is like a movie. You see all these squad cars flying up, slamming on their brakes, wheels squealing, all the cops jumping out with their guns out. Where's the gun? Where's the gun? Where's the gun? What gun? What are you talking about? Where's the gun? Where's the gun? I don't know what you're talking about. Well, he never took his holster off his hip. The technician in the CVS saw the holster and called the police saying he has a gun. So police don't dispute the fact that they opened his trunk, firearm and ammunition in separate compartments. They then ask him the $1 million question, and he violates Josh's rule number 1, never to speak to the police. They say, can I see your license to carry? Oh, I don't have one. He gets prosecuted and convicted. Different case, up close to Monroe, but thankfully still in Lackawanna County. Individual is not a firefighter, but a fire assistant, known in the community. It's a rural area, and he's on his way to the range, has all the firearms in his vehicle, and he gets a call from a close family friend. She's a victim of domestic violence. Unfortunately, she doesn't have a vehicle to get out of the home. She's called the police, and they've told her, as we're accustomed to, well, we're only 45 minutes away. So he immediately goes over to her, to pick her up, to get her out of that environment. Just about the time that she gets in the vehicle, they see a squad car pulling up. Well, she wants to file charges, so he pulls over. Cop comes up, cop knows him. They work together all the time. Hey, Jimmy, how you doing? Oh, I'm good. So he asks a $1 million question that I always love that the police ask. Is there anything in the vehicle I should know about? Well, they're friends. There's no, well, I had all these firearms. I was heading to the range, and I got the call, and, I came over here to help her, so, okay, you have your license to carry, right, Jim? Oh, why would I have my license to carry? I'm not concealed carrying a firearm again. His commanding officer directs him to file charges against Jimmy. Thankfully, in this occasion, we go in front of a magisterial district judge that is so incensed that the police would bring charges in this situation that, in addition to throwing out the charges, he tells the officer that if he ever comes with such ridiculous bullshit, that was his words, in his courtroom, that they would never find a case that they would be successful at a preliminary hearing on. Technically, the judge is probably wrong. While there are defenses that would be available to Jimmy, and I'm just making up the name Jimmy, it's not his real name, but technically in that situation, it probably had to go to a common police judge on some of the defenses, and that the magisterial judge should not have thrown it out just on thankfully, we had a judge who saw what was right and what was wrong, and he took the bull by the horns. Yeah.
Are you talking only handguns or long guns as well when you talk about a permit?
So with a license to carry, it covers you having a loaded handgun in your vehicle. The transportation laws, on the other hand, while one would assume that they would apply only to handguns, because of the amendments that have been done over the years to Section 6106, certain portions of 6106 talk about rifles and shotguns. And since any appeal would go up to the Superior Court, who I have little faith in, it's my advice to any of my clients that the transportation laws apply to rifles and shotguns as well as handguns.
So your handgun permit is essential?
Yes. In my opinion, to ensure that the best insurance that you can get yourself is paying the $20 it is for a license to carry that's good for 5 years. Because then you're exempt from the transportation laws. Then you can go to the range with your handgun or your rifle, meet up with your buddy, and on the way back, stop and grab a bite to eat and not be concerned.
I appreciate that. It never occurred to me to be concerned to carry that in my mind or any other long gun stuff.
Oh, I'm acutely aware. No rational person would be. And that's why I say these draconian laws are absolutely obscene and ridiculous. But that is one of the major reasons why I tell everyone to go out and get your license to carry. And I don't care if you never want to conceal carry on your person, that's fine. I'm not going to be the person who's going to tell you you need to conceal carry. But go out and get the license, because it gives you so many protections in the law that it pays for itself. It's like gold. You should, because the law does say upon valid demand you're supposed to produce it. So you should have a copy of it. Now, law enforcement can call in to an offline database through the Pennsylvania State Police to check if someone has a license to carry at any point in time. But you, yes, should have your license to carry with you.
Actually, I have a two-part question. The first one is, I sometimes open carry, which we all know is legal, and I have a license to carry.
Good.
When you go in a public building, does it not have to be specified in a publicly conspicuous place that they do not allow you to carry firearms in their building?
To place you on notice for trespass right off the get-go, yes. But that does not mean that if they don't have those signs and an agent of the business comes up to you and says, we don't allow people with firearms in here, that you can continue to be there. You need to be provided some form of notice, whether it's verbal, visual, or otherwise, to be on notice that at that point you're trespassing. Now, again, the law is complex. If you're given a verbal notice of it, it's considered a more severe violation if you then refuse to leave. But generally, I tell everyone, if you're confronted by a store owner or such who says, we don't allow this, don't argue with them. You're not going to change their mind at that point in time, and you're just asking for a recipe for disaster. Leave the leave if you're inclined. Write a professional letter to the business saying, on such and such a date, I was here, I was told by, your employee or that you don't permit individuals who are lawfully in possession of firearms to carry them for purposes of their own self-defense. Unfortunately, if that is your policy, I'm no longer going to be able to frequent your store. You'd be amazed at how a letter like that can have an impact on a store owner, especially a small store owner, and all of a sudden you might get a letter back saying, that wasn't really thought out too well, or maybe, Jimmy didn't know that that's actually not the store's position. So your second part.
Yeah, my second question was, this actually happened to Deborah and I. Back on April 19th.
We only talk about hypotheticals here.
Okay.
So there's no...
Hypothetically, this actually happened. We were on our way back from Florida, and we just crossed the Georgia line into South Carolina and were involved in a major car accident.
Right.
I had 5 loaded handguns on my person. Well, put that 4 in the vehicle, the trailer, and 1 in my pocket. We, of course, were taken away by ambulance. All the loaded weapons stayed with the crashed vehicles. She informed the police about this. The day later, when we got back to our vehicle, the police knew about this, they had all my loaded firearms in a bag on the back seat of the truck in a non-secure facility that anybody could have reached in, grabbed a loaded firearm, and done whatever they wished with it. If something would have happened, would I have been liable for somebody creating some criminal act with one of them firearms?
So we're talking about Mensa candidates that are police officers.
Exactly.
Okay, just want to make sure we're on the same page. In that situation, while you would probably end up named as a defendant in the action, I would think that you would quickly be dismissed as a defendant, because us lawyers, you know, we sue everyone we can who has any relation to the matter. But I would think in that situation, because the police actually created the danger, that it would be the officers that really would end up remaining in the suit and potentially be liable in that type of situation. So we talked a little bit about open carry being lawful and the transportation laws that you should all have a license to carry because of it. I see we have a question back in the blue stripe.
But not a citizen of America, you can get a concealed carry permit. Can you explain constitutionally one way or the other why that's right or wrong, even though that's what it is?
Great question. It reminds me of a case that I spoke to a gentleman about a number of years ago, and unfortunately he didn't want to move forward with a federal challenge because I thought it was phenomenal. His situation was he had a license to carry here in PA. He had renounced his citizenship during Vietnam, went to Canada, and then, as some of you may be aware, Carter gave a pardon to those people. But it wasn't exactly a pardon. Most people don't realize that if you renounce your U.S. citizenship, not in relation to what they call draft dodging, just generally, there is an expedited process for you to become a U.S. citizen again. If, on the other hand, you renounce your U.S. citizenship in relation to draft dodging, as it's been called, then you are precluded from ever being able to obtain U.S. citizenship again. And what Carter did is he didn't pardon the individuals. Rather, what he did is he said to those, the law shall not apply in relation to the prohibition on becoming a U.S. citizen again. And so this individual went through and became a U.S. citizen again. And what federal law says, and I hope I get the language exactly right, it's been a little bit since I read it, but it basically says an individual having been a U.S. citizen, is an individual having been a U.S. citizen who renounces his citizenship shall be precluded. Well, my individual was not someone who was no longer a U.S. citizen. He was back to being a U.S. citizen. But ATF was taking the position that he was still prohibited. I didn't agree with that, and I still don't. Because regardless of where you stand in relation to individuals who draft dodge and that, the letter of the law says someone who is not a U.S. citizen who previously was, my client currently is, or was at that point in time, a U.S. citizen. So, but in relation to your question, I think where it comes also from is that you can have foreigners here who have lawful rights who are not quote-unquote U.S. citizens. Most people don't realize, for those of you who don't know, I'm a big fan of the National Firearms Act of 1934. It's all the cool weapons, so machine guns, silencers, short-barrel rifles, short-barrel shotguns, destructive devices, and silencer, any other weapons was categorized. So they're the fun toys, as I call them. You can be a green card holder and own NFA firearms, and that's a surprise to people. And so also, if you are here on a temporary visa, like a school student, maybe someone who comes over from England, comes here, if they get a hunting permit, then under federal law, they are eligible to own and possess firearms and ammunition. And in that situation, they may want to apply for their license to carry here in Pennsylvania, and they would be entitled to it even though they are not a citizen of the United States. And federal law does differentiate between citizens of the United States and non-citizens in different immigration statuses of individuals who are here as non-citizens. So it really gives those rights. Yeah, in the back.
Joshua, will we ever see the day when our concealed carry permit will be honored throughout the whole country? I know for me and many people here, traveling to Maryland, New Jersey, New York, it feels like I'm leaving the United States.
You have to crawl under the barbed wire. Was that the blinking light for you? I can't honestly say. National reciprocity is out there. It's being pushed. The events from yesterday may be a precipitous to move it along. Of course, within 3 hours of the events for yesterday, we heard calls for more gun control. Like that's going to change what occurred. You know, with regards to national reciprocity, I'd like it. The problem with all federal laws that are, or excuse me, federal bills that are pending is that they can change so drastically by the time they're enacted. It's difficult for me to give advice to people on what they are because I don't want anyone believing that this is what it's going to be when it gets enacted. Meanwhile, they changed it 100 different ways in the interim. I will say that I think there's an option out there that's not being utilized. As I see it, there's basically 4 options for any type of national reciprocity. That's the laws that you're from, the laws of the state that you're from apply where you're at. So if you're in New Jersey, the law, and you're from Pennsylvania, Pennsylvania's laws would apply. I have a big issue with that because, you know what, I think that's violating the Constitution because now we're subjecting other states to having to comply with other states' laws. And quite honestly, law enforcement doesn't know the laws of the state they're in, let alone all 50 other states. The second option is that we have the laws the state you're in apply, which would seem to make some good sense. The problem with that is the laws are so complex. When I do a state and federal firearms law seminar, it's usually 4 hours and we don't get through everything. How is any person supposed to know all 50 states' laws to be able to comply with them? So I have a problem with that option. Third option, federal law steps in and says, within these guidelines or criteria, you can possess a firearm in any of the states. Well, again, I'm constitutionally oriented, and I have some issue with that because now we're eroding states' rights again. So I think what the fourth option that no one's talking about, but which I've proposed in the past, is really the best. What we do is we require each state to put out an easy-to-understand explanation of what their laws are in non-legal terminology. And if someone relies upon that statement, declaration, whatever you want to call it, of the laws, they are immune from prosecution. So if a reasonable person could have interpreted it the way that individual did, they can't be prosecuted even though they technically violated the laws of that state. I think that is the reasonable resolution that everyone could agree to, because then if I'm going to New Jersey, I go on New Jersey's website, I pull up their page that gives me this easy to understand guide to their laws, and as long as I comply with that, I'd be immune from being able to be prosecuted, but their laws would still be applying. So, yep, in the back.
Does my Pennsylvania driver's license tie with my permit?
Generally, no, and why I say generally no is there is some discussion that there's a new system some counties are using where it may be interrelated when they do a driver's license review, but it should not be. It's always been an offline database because the law actually specifies that the information can only be disclosed to a law enforcement officer where it's relative to the course over speeding. That doesn't have anything to do with whether you have a gun or whether it was lawfully possessed or that. So generally no, but I have heard some rumors that there are maybe 2 or 3 counties right now in the Commonwealth that do have it interlinked, which is another problem because now we have the operators of that system having access to confidential license to carry firearms applicant information, which is a felony of the 3rd degree and also has civil ramifications. So to answer your question, no generally, but it's possible in a couple of small areas. Yep.
Joshua, could you answer for me about what I'm hearing on the radio about insurance?
Okay.
And that, like, Hannity's saying you gotta have it because, you know, it'll save you from getting sued.
Well, you're never going to prevent yourself from getting sued. You know, that's a matter of how soon any criminal charges or civil action is thrown out of court. But I can say that having insurance or prepaid legal can be very beneficial to you. Obviously, it's going to depend on your situation. I have some clients who, although they wouldn't really like it, they could self-insure. Now, if you're charged criminally with, you know, some sort of violation, you know, you use your firearm in self-defense, you can look at spending $50,000, $75,000, $100,000 at the trial court level before you get to appeals. If you go all out, have all the experts and all that you want Masada Ayub to come in as an expert for you. While it's an outlier, most people don't realize that in the George Zimmerman trial, he spent over, well, he would have spent if he had the resources, $2 million. And that was the most justified use of force situation that's ever been prosecuted. It was absolutely ridiculous. And right now I have a case in Lancaster where an individual pulls out his firearm, does not even use it because the neighbor took a metal stake and hit his mother, fracturing her wrist. And he's merely trying to prevent the situation from going any further. He had, in my opinion, all justified right to use lethal force in that situation and kill the neighbor. And now, because the detective had just gone through 2 different crime scenes and was too tired, he turns it over to the young rookie officer who has no experience. Now, he's being charged criminally for this situation, for protecting his mother. And we have those protections in our stand your ground, that you can stand in a third person's shoes. And in fact, he was right next to his mother when this metal stake gets used and her wrist gets hit. So he was in danger himself. So it wasn't even having to stand in a third party's shoes. We're hoping that the district attorney is going to throw that out. But there's a case he was completely justified. And I have a report from Andrew Bronca. He's an attorney who only does consulting in self-defense cases. He wrote the book, The Law of Self-Defense, which I highly recommend. He wrote a 100-page report on this and said, there's no way possible that there's anything criminal in his conduct. But, you know, again, sometimes you get an officer. So getting back to the underlying question, it's a cost-benefit analysis. Look at the costs associated with it versus the benefits. Make sure that they cover items beyond simply a firearm. There are some that would only cover a firearm. So let's say you have a malfunction with your firearm, can't get it to function, you go to your knife and you end up stabbing the guy, they're going to say, oh, no, we don't have to cover you in that self-defense situation because you ended up using a knife. The good ones out there, Firearms Legal Protection, USCCA, United States Concealed Carry Association. There are a number of them. The only one I'm going to honestly tell you to run from is one called US Law Shield. You can go online and do a Google search. They go by Pennsylvania Law Shield here in Pennsylvania, Texas Law Shield in Texas. They're under a class action lawsuit in Texas for being a scam. They're one of the ones that you don't get to pick your attorney. That's another thing you should look for, is whether they will give you the right to pick the attorney that you want versus the attorney that they're going to put up for your defense. So do look into that, but beyond that, like I said, Firearms Legal Protection, United States Concealed Carry. My guy out in Lancaster was a USCCA member. They've been absolutely great getting funding up for experts in that immediately. So I definitely recommend it if you're not in a situation where you have 25, 50 grand available to you, and how many of us do?
We have time for 2 more questions.
Okay.
Thanks for coming tonight, Josh. Congratulations on your recent appointment to the Maryland State Bar. Great accomplishment. I want to expand a little bit on Jim's question earlier. Concealed carry and gun-free zones. Because we all know there's no shootings in gun-free zones, right?
Oh, yeah.
Yeah, joke. If an establishment, a movie theater, a tavern, whatever, has a sign posted outside, firearms prohibited on the premises, and any one of us is concealed carry, which I'll totally admit, I've gone into premises that are marked, no firearms on premises, movie theaters in particular. If in the event,
We're going to edit that out of the video.
I was kidding.
We're only talking hypotheticals here.
Hypothetically, exactly. In the event that you utilized your firearm to end a threat, are you setting yourself up for additional liability and/or criminal charges because you entered that premise, you concealed carry, no one else knew you had it, but you took action to end the threat?
So the answer is yes. You could be prosecuted if they could show that you knew that it was a prohibited area and you went in anyway. Now, of course, in a situation where you neutralize the threat, I think it's going to be difficult for a district attorney to bring charges against you. And in that situation, I am definitely going to want a jury trial because you're going to be pulling people from that locale who are probably thankful, maybe some of them you saved their lives. So I think it would be difficult, but to answer your question, if you violate the law, the DA could technically prosecute you, although it may be political suicide for that district attorney.
We have time for 1 more question.
I have a quick question. What is the legal law for a muzzle loader loaded?
Okay. Technically, antique firearms are not firearms here in the Commonwealth unless you're a prohibited person, but I would never recommend that you have a loaded muzzleloader in your vehicle, partially because of the safety concerns. I know a lot of people say there really aren't any. I actually was aware of one situation where everyone believed it couldn't possibly go off, and yet it did. So I think for safety reasons, in relation to the Uniform Firearms Act, again, as long as you're not a prohibited person, it actually does not constitute a firearm. As I said, in relation to the transportation laws, there's some problems because of the amendments to Section 6106 over the years. It's possible a district attorney could try to argue it's still within the gamut. So again, I'm one that I'm going to tell someone, don't take the risk, it's not worth it. I understand that it's the loss of the round in that if you've gone out hunting ready and you don't see Bambi or that beautiful buck. But at the end of the day, I can tell you that cost is so minimal in relation to the prosecution. And even other than the prosecution cost, the emotional impact. People don't realize the emotional impact. And I tell people all the time, people say, I see someone in my house, I have legal right to use lethal force. And I say, yeah, that's right, but think about whether you really want to. Because if you can see clearly that they don't pose you any risk and they're about to run out your door, yeah, they may have your flat screen, who cares? Even if you don't have insurance, I understand you work hard for it, it's not worth it. Because people don't realize with the divorce rate being over 50% in the United States, anyone want to take a guess what the divorce rate is with someone who's involved in a self-defense situation, even a completely justified one? 89%. Because the other spouse cannot comprehend what the spouse who utilized force is going for, and going through. And it doesn't even have to be that they actually killed the person. I've been involved in a number of situations where they end up trying to kill the person. I mean, they shot to kill the person, but they end up hitting them in the arm. And that has a monumental emotional impact. You're going to need psychological care after any type of incident like that. And it's no different than what our soldiers coming back from overseas are having to deal with. And if you saw American Sniper, Chris Kyle, I mean, that was a really good visualization of what our soldiers do come back to. And to them, they're the same person. They don't see themselves as different. To us, they are. And that's really the problem, is unless you can give them the time and space to decompress and compartmentalize everything, let them know that you're there for them, but not always on, you're not the same person that you were before you left. They'll be able to eventually deal with it in all likelihood, but you're looking at probably a year to a year and a half before you can get to that point. And, you know, why I brought up American Sniper, there was that time where he goes and runs after that dog that's just barking and he's ready to kill that dog. It wasn't computing for him. So, you know, I know we're out of time, but, you know, I think it's an important point. People don't realize when someone has gone through post-traumatic stress disorder or is living it, what it's like. And it can be absolutely devastating. And, you know, just give them some time and make sure they know you're there for them, but don't constantly be in their face if you're someone different, because to them, you're the same person. And then they get frustrated with everyone telling them, well, Jimmy, you're not the same. Well, Jimmy thinks he is. Jimmy will come around in the proper environment, but you gotta give him that time. So I know we're out of time. I really appreciate everyone coming out tonight. Hope you learned some things. Like I said, when I do a regular firearms law seminar, it's usually 4 hours, and we still don't get through all the laws. On our blog, we do put up when we do those firearms law seminars, and obviously, Berks Patriots ever want to do a 4-hour firearms law seminar, I'm more than happy if you guys want to try to do it for a revenue funding event or such, you know, just let me know. But thanks again for having me.
How many of you would be up for getting Joshua back here just to do a stand your ground seminar in one of our meetings? Let me just have a show of hands. I think that's pretty much unanimous. Would you be willing to come back for that? Because a lot of people have questions. I've seen there's like 3 people that get to ask one, and we all come up with things all the time. Now, I do have one question, and I think it'll clear up one person's question here. There is a certain establishment in Berks County which a friend of mine will say frequents, and he carries a firearm. Yet the owner of the establishment, it's a bar, a restaurant, was okay with him carrying a firearm. Is that legal in that establishment?
Yes.
Because the owner permits it.
That's correct.
So there's no truth to the fact that everybody says, oh, if there's alcohol, sir, you can't have a firearm.
No, that's a myth that I think there is no prohibition on having a firearm in an establishment that serves alcohol here in the Commonwealth. I think it came from Virginia. They used to have a provision that you could never be in any type of establishment that serves alcohol, even if you weren't imbibing. I think Virginia has changed that law to some degree, but here in Pennsylvania, we've never had it. Now, that being said, remember I talked with you about character and reputation, and your license to carry can be revoked. So while there is nothing in the law that would preclude one from imbibing in libations while carrying one's firearm, I'm going to recommend against anyone doing that. I know you've seen law enforcement officers doing it. I'm still going to tell you, do not do it, because it is possible that if the sheriff became aware of it, that your license to carry could be revoked under that character and reputation clause because of the dangers of mixing alcohol and firearms.
Just a couple of brief announcements. Our July meeting is going to be on, it's Tom DeWeese, and do you realize, and I'm only just learning this, I stated earlier that I'm pretty stupid when it comes to technology, okay? And I just got a smarter phone than I am, okay? Very smart. No matter where Deborah and I go, it's now asking me questions like, how did you like your meal at this restaurant? Like, how the heck did you know I was even in the restaurant? I'm serious, this drives me crazy. And we do not realize how much we are being tracked. Everything we do, they can track you through your phone, they can track you. You're on camera, on average, everyone's on camera about 12 times a day. Not a bad thing in some situations, but this technology is actually being used to target us. And that's what Tom DeWeese is going to be talking about. I don't think we realize how much, at least I didn't, how much this technology is really targeting us and following us, knows what we're doing, knows who we associate with, knows everything. On the surface, sounds good, right? Well, where is our privacy rights? They don't exist anymore. It also goes with your smart meters, things like that. There's certain areas where you have smart meters. Who cares? I could care less if you pay $1,000 a month for electricity. I don't care if you have 100 lights in your house on all day long. If you're paying for it, it's your bill. Well, we're being tracked that way. So anyways, that's what our next speaker will talk about. I'd like to bring up Oath Keepers. They're having a meeting on the 18th at Wegmans Restaurant. And it's on basic firearm safety training. If you do care about your Second Amendment rights and want to learn a little more, their meeting starts at 6 p.m. All Wegmans ask, if you haven't ever been there, it's right there on 61, is that you just contribute a little bit to buying something to eat that day. So maybe get your dinner there. Gun raffle, as you know, we're selling tickets. Everyone needs a firearm. Lisa yelled it in the back. Charlie has the firearms there. Joshua's going to stick around. You can ask him questions afterwards. I'd like to bring Rod up for another quick announcement. This one's quick. I got the hook ready.
It is quick, except I want to put a footnote on what I told you earlier. When I say our legislative committee goes out on a limb when they think they are right, and in rare exceptions have we been proven wrong, but the one vote I want to throw out here that I failed to add. Loman Henry, we had him here as a speaker years ago. He's in charge of the Leadership Conference of Pennsylvania. He brings in top people in this state, in this country, to speak. They put literally hundreds of people at their meetings. Here's what he said, quote, Senator Wagner is absolutely correct. It does nothing in the immediate future, and likely so little thereafter as to be totally worthless. I read your letter to Charles Mitchell, and as you copied me, very well done and spot on. So, as far as I'm concerned, every person I know that has any significance at all that I copied, all come back to the same thing. The bill is a piece of crap, period. Anyway, so much for that. I have a selfish announcement, folks. As maybe you might see my wife here at times on a walker, and I bought a Rancher several years ago, and she's after me to get little things done here and there, and I can't get the job jar empty. Anyway, I got some significant things I still got to do. I got a lot of little things outside, painting the metal railings, painting around windows and whatever. My point is, if any of you folks have a grandchild or a son that look to get some summer employment or some summer work, I'll certainly pay a respectable, competitive wage, and there must be at least $1,000 worth of work around the house. If anybody has anybody you think could use a few bucks, come and see me after the meeting. I'll give you my business card, my Patriot card, and tell them to get a hold of me. Thank you.
I've seen Rod's honey-do list. I think it's more like a honey-do book. But anyways, because honey don't do, that's what his wife says. So, at this time, we'd like to close this meeting. If you could join me in prayer. Gracious Heavenly Father, we do thank you and praise you for this time we've had together. We thank you for those who fight for our Second Amendment rights, those who fight for our freedoms around you, keep them all safe. We pray that they would do that which is pleasing in your sight, Father, and that your will will be done, not ours, but your will. And we just pray for this current situation in our country, Father. There's a great divide. And there needs to be something done, Father. There needs to be some dialogue made. There needs to be rhetoric stopped. And there needs to be people coming together to make things better for all of us, Father. Everything can't be our way. Everything can't be their way. But there is some common ground we can work together with. And I just pray that those people would raise up, that they would come together, and they would do that which is right for this nation and for you. And it's in Jesus' name we pray. Amen. Thank you all. How many